Mr. Beebe, please raise your right hand.
I'm right now.
Mr. Beebe, you can please state your true and correct legal name.
Say it again.
Can you please state your true and correct legal name?
Durante PV.
And are you the same person referred to on the indictment you just signed of 22 SC 183572? Did you just sign that indictment?
Yes.
Okay. Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
How old are you?
23.
And how far did you go in school?
I went far.
What's that mean?
Like 12.
You went to 12th grade?
Mm-hmm.
Did you graduate?
Mm-hmm.
Is that a yes?
I mean, yes.
Okay. Are you able to read, write, and understand the English language?
Yes.
With respect to indictment 22 SC 183572, how do you plead to conspiracy to violate the Racketeer Influence and Corrupt Organization Act? Guilty or not guilty?
Guilty.
How do you plead to theft by receiving stolen property? Guilty or not guilty?
Guilty.
How do you plead to violation of the Georgia Controlled Substance Act in count 9? Guilty or not guilty?
Guilty.
How do you plead to violation of the Georgia Controlled Substance Act as to count 10? Guilty or not guilty? How do you plead to possession of a firearm by a convicted felon?
Guilty.
How do you plead to participation in criminal street gang activity?
Guilty.
How do you plead to armed robbery reduced to robbery by force?
Guilty.
How do you plead to hijacking a motor vehicle in the first degree?
Guilty.
Is this guilty plea freely and voluntarily given with a full knowledge of the charges against you?
Yes.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have only 4 years from today's date for the felony charges to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Your Honor, had this case proceeded to trial, the state of Georgia would have proved beyond a reasonable doubt that in late 2012, within the Cleveland Avenue area of Atlanta, Georgia, that YSL, who claimed affiliation with the National Blood Gang, was formed. The founders of that organization were Jeffrey Williams, also known as Young Thug, also known as Slime, Walter Murphy, also known as DK, and Trontavia Stevens, also known as Tick or Slug. That this organization uses a number of different identifiers, including colors, clothing, tattoos, and hand signs in order to show affiliation with that organization. That this organization is part of the enterprise, which is Young Slime Life, and that this defendant was a member of this enterprise and conspired to and associate together with others for the common purposes of illegally obtaining money and property through a pattern of racketeering activity and conducting and participating in the enterprise through a pattern of racketeering activity. In furtherance of the conspiracy, he engaged in a number of different crimes. Specifically, Your Honor, 2 of those crimes in racketeering activity, first being one occurring on May 8th, 2012 at 151 Cleveland Avenue, which is in Southwest Atlanta, Georgia, 30315, which is an Exxon gas station in what is known to be the Young Slime Life gang territory. That Mr. Beebe was a part of an undercover sting operation at the gas station. Officer Applewhite, APPLEWHAITE, was operating in an undercover capacity. He went inside of the gas station and encountered the defendant. Officer Applewhite asked to purchase marijuana. The defendant asked how much. How much marijuana? Officer Applewhite advised he wanted $20 worth. The defendant then went into the area of the store, weighed up the marijuana, and gave that marijuana to Officer Applewhite. Once the sale was completed, other officers came in and placed Mr. Beebe under arrest. When they placed him under arrest, he was found with marijuana on his person as well as a gun. The gun was then ran and it came back stolen out of East Point Police Department from a car break-in in August of 2019. Additionally, Your Honor, about a year and 6 months later, in October 12th of 2021, this defendant, along with co-conspirator Christian Eppinger, were at 47 Cleveland Avenue, Southwest Atlanta, Georgia, which is also in the Young Slum Life gang territory. While there, the victim, Mr. Darius Smith, was at that location, which is a park next to a library. Mr. Smith was speaking with a friend of his, and while speaking with that friend, there were two black males described. One had a blue and black ski mask with a black and silver handgun. The other suspect had a black ski mask with a black handgun. They approached Mr. Smith and stated to him, "Give up that chain." Mr. Smith had a large chain that was very identifiable. That chain was a diamond encrusted chain that looked like a house and said Trap Commander on it. They also took additional jewelry and other items from Mr. Smith, to include earrings, a diamond gold necklace, 2 iPhones, his car keys. They then went and jumped inside of his vehicle, which was a 2003 GMC Savannah. They then fled the location after robbing him. Again, both of the individuals had guns. Mr. Smith initially called 911. He had left the location. A friend was able to take him to his brother's house, which was in Clayton County. When he called 911 in Clayton County, they advised he had to come back to the city of Atlanta. He did come back to the city of Atlanta and was able to encounter police, where he reported what happened to him a few hours earlier. During his time in explaining to the police what happened, he gave a description of one of the defendants. He said that he knew or was familiar with one of the defendants from the neighborhood. Although he had a ski mask on, he noticed 2 things: his eyes as well as his hands, and that he was missing a finger. After that, Mr. Smith was able to provide to law enforcement officers social media pages of first Durante Beebe wearing his chain and identifying him as the person with the missing finger that had robbed him. Mr. Beebe was on social media promoting the chain, having the chain, some would say flossing the chain in front of the camera, which was the chain that was stolen from him. Further investigation into social media, the officers were able to identify the co-defendant, Christian Eppinger, as the other person who robbed him. Officers were also able to get the social media information from Instagram, and they actually found on Instagram a recording of Christian Eppinger bragging about robbing Darius Smith that was turned over in discovery. After arrest warrants were taken out, Mr. Beebe was arrested, interesting enough, back at that same location in November of 2021 at the same 47 Cleveland Avenue, where he was arrested, arrested on these charges. And then Christian Eppinger was arrested subsequently on these charges in February of 2022 after he shot Officer David Rogers. Additionally, Your Honor, we have social media postings of Mr. Beebe and Mr. Eppinger that are a part of our overt acts in this indictment, which shows them being part of and associated with the conspiracy. Mr. Beebe in Act 143 of count 1 of our indictment is posting a picture along with co-conspirator Christian Eppinger wearing what we call an OTS sweatshirt, which is only the slime sweatshirt and sweatpants, again showing his association with the enterprise and the fact that he's acting in furtherance of this enterprise and to promote this enterprise, Your Honor. This is some of the evidence that the state would intend to show if this case were to move forward with trial, Your Honor.
Mr. Beebe, good afternoon, sir.
Good afternoon.
Sir, did you have the opportunity to fully discuss the facts and circumstances of this case and the matters in indictment 21 SC 177912 and 23 CP 218502 with your attorney, Mr. Partridge, to your satisfaction?
Yes, sir.
And do you have any questions about any of the rights that you give up by entering a guilty plea in this case? Those rights were set forth on the record by Ms. Simone Hilton from the District Attorney's Office. Do you have any questions about those rights you wish to ask me?
No, sir.
Did you give this plea, did you have a chance to also read and sign the indictment that I'm holding up here?
Yes, sir.
Okay, do you have any questions about the indictment as it pertains to you in counts 1, 8, 9, 10, 11, 12, 27, or 28 you want to ask me?
No, sir.
All right, I don't know if the indictment's been signed, the plea has been entered. Mr. Beebe, based upon the responses that you've given during the court's inquiry, I'm going to find that your guilty plea is freely and voluntarily entered. I find a factual basis for your plea, and I'm going to accept your plea as tendered and as negotiated. So as to count 1, conspiracy to violate the Racketeering, Influence, and Corrupt Organizations Act, this court will sentence you in accordance with your negotiated plea to 10 years to serve 5 years with the balance probated. As to count 8, theft by receiving stolen property felony, this court will sentence you in accordance with the negotiated plea to 2 years commuted time served concurrent with count 1. As it pertains to count 9, violation of the Georgia Controlled Substances Act, this court will sentence you to 2 years commuted to the time you've already served concurrent to count 1. Did I say count 8 correctly? Count 8 is theft by receiving stolen property.
Yes.
All right, okay, let me just redo that one again. That's theft by receiving stolen property firearm. The court will sentence you to, that's count 8, 2 years commuted to time served concurrent with count 1. We go back through count 9, that's a violation of the Georgia Controlled Substances Act. That's 2 years commuted to time you've already served concurrent with count 1. As it pertains to count 10, violation of the Georgia Controlled Substances Act, this court will sentence you to 2 years commuted to time served concurrent with count 1. As it pertains to count 11, possession of a firearm by a convicted felon, this court will sentence you to 5 years to serve concurrent with count 1. Count 12, participation in criminal street gang activity, this court will sentence you to 5 years consecutive to count 1. And on count 27, armed robbery, this court will follow the recommendation, and on a reduction to robbery by force, will sentence you to 10 years to serve 5 years with a balance on probation. As it pertains to count 28, hijacking a motor vehicle in the first degree, this court will sentence you to 10 years to serve 5 years concurrent to count 1 with a balance on probation. The special, I'll also give you credit toward the sentence that has been or is going to be adjudged from November the 17th of 2021 toward the adjudicated time that you may have to serve on a couple of these counts. The state has also acknowledged that they're going to pull or withdraw the recidivist notice, so that you will be eligible at some point in time at the discretion of the Department of Corrections, as we mentioned, to be parole eligible. I don't know when that will be. I'm just going to tell you that because that's their exclusive purview. But at some point in time, by withdrawing that notice, they will be able to consider you for parole, okay? All right, special conditions of your sentence are as follows. You shall abide by each and every and all terms of the negotiated plea. You understand that?
Yes, sir.
Okay. If you're called to testify by any party in this case, the state's not going to call you, but if any of the other parties call you, you have to testify truthfully, okay?
Yes, sir.
All right. You can't possess any guns unless and until your right to do so is restored. You understand that?
Yes, sir.
All right. You cannot commit any criminal acts. You understand that?
Yes, sir.
You can't promote or allude to YSL in public or on any social media platform. You understand that?
Yes, sir.
All right. And failure to abide by any special condition of probation shall result in a revocation. That means you'll come back before myself or another judge to determine whether or not you've violated the terms and conditions of your probation. So it will subject you to a revocation, and if that revocation is proven, the state's telling you that they're gonna ask that any remaining portion be revoked. You understand that?
Yes, sir.
Okay, all right. You also acknowledge the fact that you've given up your Fifth Amendment right related to any statement contained within the defendant's factual acknowledgments, which is a separate document which you are going to sign. You understand that, right?
Yes, sir.
Okay, all right. Mr. Beebe's explained that to you? Mr. Partridge has explained that to you to your satisfaction?
Yes, sir.
Okay, all right. And you also agree that you'll make no attempt to assert a Fifth Amendment privilege if you're questioned on these matters. You understand that, right? So,
Yes, sir.
yeah, so if you're called later, if it's something you have to testify to, you'll have to testify in accordance with that, all right? All right?
Yes.
Okay, all right. Do you have any questions about the plea that has been entered in this particular case, Mr. Beebe? Anything you want me to answer?
No, sir.
All right. Are you otherwise satisfied with the advice and counsel of your attorney, Mr. Partridge?
Yes, sir.
All right. And do you have any questions about any of the indictment or any of the plea documents that you have been asked or have been presented to you?
No, sir.
All right. And do you give this, let me just ask you this one more time. As to counts 1, 8, 9, 10, 11, 12, 27, and 28, how do you plead to these particular counts under the indictment as they pertain to you?
Guilty.
And you give this guilty plea freely and voluntarily, means your own decision to enter a plea this afternoon?
Yes.
Okay, all right. And sir, then I find that based upon the responses that you've given in the colloquy in this case and the court's questioning of you, that your pleas are freely and voluntarily entered, I find a factual basis. I'm gonna go ahead and accept your pleas as tendered and negotiated, sentence you to the, as indicated. You're 23 years old. You've had enough trial in your life at this point in time. Would you agree?
Yes.
Time to have a little testimony. Time to reclaim your own life. And that you can do in this case, or if you just separate yourself from the people that you've been hanging out with. Find some new friends, find some new people that are gonna be positive in your life. And if they don't add to your life, then you need to cut them loose. Because that's the way you'll be able to have a decent life, and a life where you won't have to worry about somebody doing this all the time, knocking on your door trying to find you for some other reason. Or also put your life at risk. So just something to think about, okay? But do you have any other questions of me?
No, sir. Thank
All
you.
right, young man, then that's that.
Garlington.
Good morning, Judge Thomas Mandelli for Mr. Garlington. On this case, Your Honor, the state conveyed an offer in writing, which I've conveyed to my client. I've spoken with the state as well. At this point in time, we are declining their offer. The case will be further noticed as a result, but per discussions with the state, we would like to be able to keep negotiations open.
And today is the last opportunity to make a negotiated plea. Anything after the delay is going to be non-negotiated, regardless of whether the state or the defendant has negotiated something. We put this on a calendar a good while back. This case has been going on since God created Adam. And so if you haven't worked out something yet, too tough. We just moving it to the trial calendar. And that's all I've got to say. So you had plenty of time to talk about what could be done, and that's it. So further notice to the trial calendar, state's offer is withdrawn. Anything after this is non-negotiated.
That's fine, Judge. Thank you.
You're welcome. State versus Adams.
Just yesterday, so I'm asking for a reasonable opportunity to convey the offers of my client.
We'll do a pretrial. Come back to you. All right.
Judge,
Yes.
let me make sure everyone is on the mic.
I'm sorry.
Can we make sure that all speakers are on the mic or at a mic?
Okay.
Please.
Were you able to get the last statements? Ms. Jones, were you able to get the last statements?
Yeah, she was very low, but I did hear her. I just
All
want to
right.
make sure.
All right, folks, court reporter is on the Zoom, and you'll need to be at a microphone that's actually working. I think that one might not have been working. Is it? All right. No, she got, Ms. Jones said she was it was difficult to hear, but she got it. So, all right, Damone Blaylock.
Good morning, Your Honor.
Good morning.
We received an offer from the state. I have reviewed that with Mr. Blaylock. At the moment, he would like to reject that offer, and we be asked to please be further noticed for a trial calendar. I'm sorry.
Go ahead.
There was one other thing that I wanted to just discuss with you. As I notified the court that I had filed a motion in reference to Mr. Blaylock's severance from the original trial. An order on that motion was filed on May 10th, if I'm not mistaken. I did request a hearing on that motion. I never received notice of that order until June 11th. I filed a motion requesting that the Honorable Court please reconsider that motion and allow me to be heard on that motion. There were some things that I did want to bring to the Honorable Court's attention to at least put on the record. So I would respectfully ask the Honorable Court if we could please set that for a date, and I could be heard on that motion. Yeah.
Okay. No. I decided it based on the brief. The defendant cited no authority for the proposition that the court was required to have a hearing on the motion, and so the facts and the circumstances that on the transcript from the proceeding were clear, and therefore there was no merit to going back to allow defense counsel to be able to orally argue a meritless motion. Second thing, we filed it in Odyssey, and from what I understand, your information is correct. So that's what we're supposed to do, file it, and it's supposed to go to counsel. Well, I don't know why you didn't get it, if in fact you didn't get it. But the more significant is the fact that Ms. Chavis, this case manager, emailed you a copy, and you didn't file a motion until 11 days or thereabouts after you actually clearly had notice of it because you got sent to you. And then the Superior Court rules if you want to make a motion for reconsideration, you got to do it within 10 days. So even if you didn't get it under the normal Odyssey process, you had more than 10 days before you filed the response. So it was untimely. But, you know, this is, with apologies to the Four Tops, this is just the same old song, and it wasn't good the first time. So with no disrespect intended, I'm not going to just take up court time to allow somebody to come in to argue a case when the pleadings clearly make, and the facts aren't really in dispute. Therefore, that motion for reconsideration is denied.
Okay, Your Honor. I understand.
You further
that.
notice into the trial calendar, correct?
Yes, Your Honor. I just put just a few things on the record just for purposes of Mr. Blaylock.
Yeah, go ahead.
Just as it pertains to that motion, I did want to say, so again, that Mr. Blaylock did not consent to his severance originally.
Which is in the original brief.
Yes,
Go ahead.
correct. So generally, the trial court is allowed to sever an individual if upon a motion by the defense or the state that it could be granted on that basis. A motion to sever was heard on behalf of all the defendants in this case earlier, which was denied. On this particular day, neither Mr. Blaylock nor the state raised the motion. Both of us actually opposed. Mr. Blaylock and the state opposed that motion. There was no finding of manifest necessity by the court. There was no facts that the Honorable Judge Glanville laid out to indicate manifest necessity on this particular day. The only information that Judge Glanville put was that it served his best interest. To be quite frank, I'm pretty sure it would serve everyone's best interest to be severed in this case. However, there were no factual findings of manifest necessity, which is what is required for a trial judge to sever a defendant. There was no facts. There was nothing pertaining to the actual evidence in the case that was laid out as to justifying Mr. Blaylock's severance. It was simply that he fell ill one day. He wanted medical treatment. Mr. Blaylock and I offered to waive his presence, offered an alternative to being severed. The Honorable Court denied that and elected to sever him despite his discontent with that. And just ultimately, there were no factual findings. There were no findings based on the evidence being confusing, being prejudicial to Mr. Blaylock, and no finding of manifest necessity by the court justifying his severance without his consent. That's all I have to say on that, Your Honor.
Question, what, if anything, you just said now that you didn't put in the initial brief?
I put most of that in the initial brief. Just the reasons that people generally have motions. I'm sure that when we come in here and I'm able to orally express certain things to you, I'm sure that I can not only have a chance to respond to what the state says, but also I can answer any questions that you may have, frame things in a different way, rather than taking up paper, putting everything in a written brief. So that's really why I wanted to be heard, just to, really be able to flesh out some things and answer any questions that you may have. If the Honorable Court stands by his ruling, I completely understand and I respect that. But I did just at least want to be able to put some things on the record.
Okay, well, let the record reflect, you just argued the motion and you haven't said anything that's going to change the court's mind. And so the motion is denied. All right.
Okay, Your Honor. Thank you. May we be excused?
Yes, sir. You can. We've got so many defendants in here. We'll have to, in an orderly fashion, allow different defendants to be excused at the time that is most convenient and safe for the sheriff to handle that. So, but you may be excused. So have a good day.
You too, Your Honor.
Hey, can I be excused? I don't feel, you know what I'm saying? My attorney that day, so can I be excused?
Who is your attorney, sir?
I don't even know my attorney name, sir.
Oh, Mr. Lalum. Okay. All right. Yes, sir. I think we received an email from Mr. Lumumba, was it yesterday sometime or whatever, indicating that he had a family emergency and needed to be at the hospital with his father, was what we were told. I think the state was actually sent a copy of that email as well. Ms. Hilton?
Yes, Your Honor. It looks like, are you here?
I am, Your Honor. My name is Attorney Kareem Cashman. I've been the
Would you get on a microphone for us, sir? And would you come on, man. I'm trying to do the best we can to, yeah. All right, that's fine. We will see what's what. All right. Yes, sir.
Good morning, Judge. As I was saying, my name is Attorney Kareem Cashman. I'm the newly appointed attorney for Mr. Cobb.
This is Mr. Cobb.
This is Mr. Fleetwood.
Fleetwood.
Well, that's half the issue.
Ms. Jones, did you get counsel's name? So I can have him spell it for you if you need to.
So I see, I apologize.
Your Honor, it appears that Mr. Luemba is the attorney on position number 5 and number 8, who would have been Justin Cobb. And so it appears that Ms. Cobb, okay, sorry.
Okay, well, we haven't got to him yet, so you can have your seat, okay? All right. Your attorney that's assigned to you, now whether or not y'all have had any in-depth discussions or all of those kinds of things, I hear what you're saying, and you're indicating that you don't even know who they are, and I appreciate what you're saying, all right? He isn't here today, so we will deal with that as appropriate. Let me say this in response to what you just raised, sir, as well as in general. Anyone that's paid any attention to what's been going on in the state of Georgia and Fulton County understands that there's a lack of attorneys available to handle these types of cases. It takes forever for the whatever the name of that organization is that I never can get these initial kinds of things straight, but when a request is made for an attorney to be appointed to represent a defendant, it takes forever for them to get somebody and put them in place, which means that it does take time for the attorney to come up to speed and to actually be able to communicate with their clients in order to properly prepare to handle a particular cases. This case has been going on so long that certain defendants may have had one attorney, then somebody left the PD's office or somebody left the Georgia, whatever they call them, Council of Defense Lawyers or whatever it is. And then somebody else has to be appointed and then come up to speed and all of those kinds of things. Well, that's what we're dealing with. So what we do is the best we can do. So if somebody hadn't had a chance to adequately prepare or they aren't properly representing their client, then we do what we need to do to make sure that that doesn't affect the ultimate result of the case. So he's not here today because he has a legitimate emergency. Now, whether or not he's talked with you, met with you, or prepared with you previously, I can't deal with that, and I have no reason to doubt what you're saying. But as far as what we can do today, his father apparently is in the hospital, and unless we've been told something that's not true, and I don't have any reason to believe it's not true. His father's in the hospital in a very serious situation, and he's there with his attorney there. We'll look further into the idea of whether or not he's adequately been prepared or been with you to do what he needs to do to represent you in this particular case. So that's the best I can tell you right now. Now, if you want to, you may want to hear what the rest of what's going on. If you would, you can stay. If you want to step out, then we can do that now if the sheriff is able to do that. Okay.
We just keep his final plea open, given that his counsel wasn't present today?
Yes.
Okay.
Let me see. Okay, next is State versus McMullen.
Morning, Judge.
Good morning. If you, yes, please.
Please.
Good morning, Judge. Attorney Lim here for Mr. McMullen. I don't have discovery yet. I am going to get it in different phases, but as soon as I get it, I'll do my best to get this case ready for trial.
You were just recently appointed.
Yes, Your Honor.
Did you not? Well, that's what I'm saying we're dealing with. Guess we'll hold this one open as well to allow. Let me see, what do we got for? Okay. All right, Mr. Lim. Then we'll leave it open and you can continue to come up to speed.
Yes, Your Honor. Might be excused.
Yes, sir.
Judge, can we get him to stay and spell his name for me, please?
Yes, M-E-N-G, last name L-I-M.
Thank you.
Thank you, Your Honor.
Yes, sir. Jarvis Bradford.
Good morning, Your Honor.
Morning.
Attorney Aisha Broderick for Mr. Bradford. An offer has been conveyed by the state, and Mr. Bradford is rejecting that offer at this time, and we would like to be further notice to trial.
All right.
Thank you.
Further notice to trial calendar. Okay, now we're on Mr. Cobb.
Good morning again, Your Honor. As mentioned, I'm Attorney Kareem Cashlin. I was recently appointed on the case not even a month ago. I've yet to receive discovery. Additionally, I have yet to receive a plea offer for my client to even convey to him. And critically, Your Honor, unfortunately, I have been unable to get in contact with my client. I don't believe he is necessarily absconded from the court's jurisdiction. I believe it's more of a clerical error in that the conflict office has not given me proper contact information. So I'll have to go to the clerk and ascertain that info for him.
Your Honor, Mr. Cobb has yet to be arrested on the warrant in this case, Your Honor. He has not been arrested, so that's probably why there is no address for him, because he hasn't been arrested.
Right. Yes, he's been, my understanding since we started, he hadn't been in custody and his whereabouts are unknown at this particular point in time.
Yes, Your Honor, he's the last defendant that has not been arrested.
And I have seen in his history on Odyssey that he might have been returned to Washington State Prison. I checked their database and he's not an inmate located there.
I don't believe we aren't showing that Mr. Cobb is in custody anywhere else, are we?
Correct. No.
No, Your Honor, not at this time, no.
All right, well, unless and until he's before the court, then there's nothing we can do about Mr. Cobb's case. I would just say, stay ready. If he's brought into custody or whatever, then you start from there.
Will do, Your Honor. May I be excused?
Yes, sir. Have a good day.
Thank you. You too.
But, you did make a official entry of appearance, have you not?
I have.
Okay, thank you. Mr. Mender.
Good morning, Your Honor. Nicole Fagan on behalf of Mr. Mender. He has been relayed a message. He is rejecting the plea at this time for the notice of trial calendar.
Okay. Ms. Jones, did you get that? No, the court reporter. I was just making sure she got, I know who you are, ma'am. So.
Yes, Judge.
All right. Then we'll further notice the case to the trial calendar. All right. And next will be Mr. Winfrey, but I don't see Mr. Francis. Oh. All right, Mr. Francis has filed a leave of absence, and he's out of the country currently, and so
permission to speak, Your Honor?
Yeah, briefly, go ahead.
Yeah, on the record, I'd like to fire that counsel that he hadn't legally corresponded with me, no type of way with this case of you saying this is the final plea. And I ain't had one lawyer visit, I ain't even got my discovery pack. So I would like to retain another counsel because I feel like I have been ineffective counsel by the lawyer visit of Mr. Frank. I don't see no time, never went to court, never met with him, never answered the phone, and I understand that when you're a citizen, I do have a right.
Yes, sir, that's true. Are you asking to be able to get someone else appointed, or are you saying that you have the resources or intend to hire private counsel?
I can hire a private counsel, or you can retain another. I'd like to be appointed another counsel.
Okay, well, let me make sure we're on the same wavelength. What I'm asking is, our understanding was that you were indigent and not able to afford to hire an attorney. Okay, well, then the question isn't whether you can hire a private counsel or get someone appointed. It would be either you end up having to stay with Mr. Francis or you're able to get someone else. I understand what you're asking, and we'll take that up at a later date because we need to have him here to be able to hear from Mr. Francis, because he didn't, I guess he got appointed right before the last time we were in court. Was that not? I'm not arguing with you. Sir, I'm not disputing what you're saying right now, okay? I'm just saying I need to have him here so we can know the reason why, if he hasn't been able to contact you or go forward with you. And unless and until we find out, we're not going to just give you another lawyer.
Well, I have my family retained when I want.
Well, you're free to do that at any time. You're free to do that.
I'm doing that now on the record. I don't want him as my attorney.
Okay, I hear you, and I just said I'm not going to deal with that until we have an opportunity to have the attorney present.
Yes, sir, I understand what you're saying.
Okay, I got you loud and clear, sir.
Yes, sir.
Okay. Okay, so Mr. Winfrey's remains open, which we would do because counsel isn't here anyway. And if we need to make a change, the court will look into that matter as to whether or not there's a justification for doing that or not. And in the meantime, Mr. Winfrey, if your family wants to hire counsel, then they're free to do that. There's nothing but air and between them doing that, but air and opportunity. And the air ain't gonna stop them.
On the record in the matter of the state of Georgia versus Antonio Sledge in 22 SC 183572. Good afternoon, Mr. Wright.
Good afternoon, Judge.
Good afternoon, Mr. Sledge.
Good afternoon, Your Honor.
And good afternoon, counsels Love and Hilton. Okay, counsels, I understand this is supposed to be a negotiated plea. Is that correct?
That's correct, Your Honor.
Yes, Judge.
All right, Mr. Sledge, can I get you to raise your right hand as best you're able?
Yes.
Do you solemnly swear or affirm that the evidence you shall give in the matter now in hearing shall be the truth, the whole truth, nothing but the truth, so help you God or so firm?
Yes, I do.
All right, you put your hand down, sir.
Mr. Sledge, please state your true, correct, and legal name.
Antonio Sledge.
And are you the same Antonio Sledge, also known as Moontum, who is listed in indictment 22 SC 183572?
Yes, ma'am.
Are you at this time taking or under the influence of any alcohol, drugs, or medication?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No, ma'am.
How old are you and how far have you gone in school?
I'm 41, 10th grade.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you are charged with the following offenses?
Yes, ma'am.
Conspiracy to violate the Racketeer Influence and Corrupt Organizations Act,
Yes, ma'am.
as well as possession of a firearm by a convicted felon,
Yes,
as
ma'am.
listed in count 30 of this indictment.
Yes, ma'am.
Do Do you understand that you have the right to plead either guilty or not guilty to these charges, and that if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
Have you had enough time to speak with your attorney, Mr. Derek Wright, about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with his services?
Yes, ma'am.
Do you waive a formal reading of the indictment?
Yes, ma'am.
Do you waive any and all defects in the indictment, including any with respect to your name?
Yes, ma'am.
Have you been arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Do you, Mr. Wright, know of any outstanding warrants that are related to these charges?
I do not.
Mr. Sledge, has your attorney advised you of the minimum and maximum sentence for each charge that you are pleading guilty to
Yes,
today?
ma'am. Yes, ma'am.
Do you understand that this is a negotiated plea of guilty,
Yes, ma'am.
which means that the state will recommend to the court the following sentence?
Yes, ma'am.
As to count 1, 15 years to serve on probation, subject to the special conditions contained in the plea agreement that I have in my hand that I will show you in just a moment. And on count 30, although you are pleading guilty, sentencing will be withheld until the completion of the initial trial of this case. After the initial trial of this case, provided defendant you have complied with the special conditions outlined in sections B, C, D, F, and I of section 3 special conditions of sentence of this plea agreement, the state agrees that the defendant shall be allowed to withdraw his guilty plea on count 30, and the state shall agree to null pros count 30. Do you understand that the court does not have to accept that recommendation? And we will read into the record the terms of the plea agreement in a moment. Do you understand that?
Yes, ma'am.
Do you understand that the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other if the court does not accept that negotiated plea?
Yes, ma'am.
I'm showing you what has been marked as State's Exhibit 1AS. Do you recognize the document in State's Exhibit 1AS?
Yes, ma'am.
And is that your signature on page 7 of 7 of State's Exhibit 1AS?
Yes, ma'am.
Your Honor, at this time, actually, and Mr. Sledge, have you had an opportunity to review each and every provision within State's Exhibit 1AS?
Yes, ma'am.
As reflected on State's Exhibit 1AS, the current charges that you face are count 1, conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act, and count 30, possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm, OCGA 16-11-133. The negotiated sentence as outlined in State's 1AS is count 1, 15 years on probation, and count 30, sentencing withheld until the years on probation, and count 30, sentencing withheld until the years on probation, and count 30, sentencing withheld until the years on probation, and count 30, sentencing.
We might need to skip forward 2 seconds. Try that.
I'm gonna inject. I think to the extent that the entirety of the agreement is not captured, I'm gonna object to skipping forward. I'll see.
Let's see.
Your Honor,
I'm not saying to skip anything substantively. I'm trying to
Right.
see if they can skip over the part where it's just repeating
skipping,
itself.
yes. We're sharing through a different screen, and we're going to go ahead and pick up
On
at
these
6:40
charges.
At 6:40 where we stopped.
It has complied with the special conditions outlined in section B as in boy, C as in Charlie, D as in Delta, F as in Frank, I as in Indigo of section 3 special conditions of sentence of this plea agreement. The state agrees that defendant shall be allowed to withdraw his guilty plea on count 30, and the state shall agree to null pros count 30. The special conditions of the sentence, as outlined in section 3, are that defendant shall abide in full by each and all of the terms of this negotiated agreement. Defendant's failure to abide by any term of this agreement shall constitute a violation of the agreement. Defendant shall testify truthfully about all matters relating to this case upon which he is questioned at any trial or judicial proceeding stemming from the facts alleged in this indictment. In accordance with testifying truthfully about all matters relating to this case, defendant acknowledges that each and all of the statements contained within the defendant's factual acknowledgments section of this agreement are true. Defendant shall testify truthfully about each statement contained within defendant's factual acknowledgments and any matters related to this case when asked to do so in any proceeding related to the facts alleged in this indictment. Defendant shall possess no guns unless his right to do so is restored. Defendant shall commit no criminal acts. Defendant shall submit to random drug screenings by the Department of Community Supervision and any agency designated by the court in this case. Should the defendant test positive for any Schedule 1, 2, or 3 drug, defendant shall within 30 days of said positive test undergo drug rehabilitation as designated by the court or the Department of Community Supervision and shall successfully complete said rehabilitation program. Defendant relinquishes any Fifth Amendment right related to any statement contained within defendant's factual acknowledgments contained within this plea agreement. Section 4, defendant's factual acknowledgments. Have you initialed each and all of the defendant's factual acknowledgments contained within section 4 of this document?
Yes, ma'am.
And is that initial AS your initial?
Yes, ma'am.
The factual acknowledgments are as follows. Number 3, while associated with YSL and to support and express loyalty to YSL, defendant and co-defendant Demikion Garlington and Quindarius Zachary appeared in a video with another person, AS, where defendant brandished a weapon used in a drive-by shooting, and where on behalf of YSL, defendant threatened to harm a person named Kel, a rival gang member who had begun a relationship with defendant's ex-girlfriend. Number 4, on or about April 28, 2015, as reflected in Fulton County Indictment 15SC 138994, defendant and fellow YSL associates Demekion Garlington and Quindarius Zachary committed a drive-by shooting using the firearm defendant wielded in the video referenced in Part 3 of this section, targeting family members of a rival gang. Number 5, defendant and his fellow YSL associates committed the drive-by shooting referenced in sections 3 and 4 above on behalf of YSL and to increase the notoriety, reputation, and fear of YSL. Number 6, defendant admitted committing and was convicted of aggravated assault and participation in criminal street gang activity, among other charges, for his participation in the drive-by shooting referenced in sections 3, 4, and 5 above. Number 7, defendant was told by another YSL associate that immediately after the murder of Donovan Thomas Jr., YSL associates met at the McDonald's on Cleveland Avenue in Atlanta, Georgia, to discuss the murder. Number 8, defendant personally knows that one or more YSL associates committed the murder of Donovan Thomas Jr. on behalf of YSL. Number 9, on January the 10th, 2015, after the murder of Donovan Thomas Jr., defendant and other YSL associates gathered at the home of Jeffrey Williams, aka Young Thug, who gave defendant and other YSL associates cash money to lay low. Number 16, defendant has personal knowledge that he and other members or associates of YSL have either participated in or directly committed at least one of the following crimes in order to increase the notoriety and reputation of YSL: murder, armed robbery, aggravated assault, attempted murder, theft, illegal gun possession, and illegal drug possession and sales. Mr. Sledge, have you had an opportunity to go over each one of the defendant's factual acknowledgments and make corrections where necessary?
Yes.
And do you now acknowledge under oath that each of the factual acknowledgments that you have initialed in this section are true and correct and accurate to the best of your ability?
Yes, ma'am.
Part 5 of this plea agreement, Your Honor, states that defendant's sentencing acknowledgments are as follows. Defendant understands fully that if he violates any provision or any special condition of this plea agreement, the district attorney can and will use the contents of this document and agreement during any judicial proceeding. Defendant understands fully that if he violates any provision or any special condition of this plea agreement, his probation for this sentence may be revoked in its entirety, and the district attorney will recommend that defendant serve any remaining portion of this sentence in confinement at the Georgia Department of Corrections or prison. Number 3, defendant understands fully that any violation of any provision or of any special condition of this plea agreement shall result in defendant being sentenced on count 30 of this indictment, and the district attorney will recommend that the defendant serve the maximum sentence allowed by law. Number 4, defendant understands fully that if prior to the conclusion of the initial trial of this case, defendant fails or refuses to testify to any fact that he acknowledges in this plea agreement, such failure or refusal nullifies any promise made by the district attorney to null pros count 30 of this indictment. Number 5, defendant understands fully that defendant's violation of any provision or of any special condition of this plea agreement prior to the conclusion of the initial trial of this case shall nullify any promise made by the district attorney to null pros count 30 of this indictment and may result in defendant being, and Your Honor, there is a typo that is in this document. It's the word should be being, and it's spelled B-E-G-I-N. I'm going to ask that defendant just strike through and initial that word, B-E-G-I-N to B-E-I-N-G.
Right through. Change it to E. Then initial right there.
And Mr. Sledge, is that your initial above the strike through of the word began to change it to being?
Yes, ma'am.
Okay. and may result in defendant being sentenced to serve as much as 35 years of confinement in the Georgia Department of Corrections or prison. Number 6, defendant understands fully that no promises, agreements, or conditions have been made other than those set forth in this document. Mr. Sledge, are these your initials on each section under defendant's sentencing acknowledgements?
Yes, ma'am.
Mr. Sledge, do you agree that the following statement is one that you have read, fully understood, and signed your name acknowledging? I, Antonio Sledge, have read and carefully reviewed this agreement. I have reviewed and corrected where necessary for accuracy each statement contained in defendant's factual acknowledgements, and I acknowledge the truth and accuracy of each and every statement listed therein. I fully understand this agreement, and I've had an opportunity to discuss this agreement and each of its provisions with my attorney, Mr. Derek Wright. No promises other than those contained in this document have been made to me in furtherance of this agreement. I freely, knowingly, and voluntarily enter into this agreement without force, threat, or coercion. Is that the statement that you acknowledged in this agreement?
Yeah, ma'am.
And is that the statement to which you sign your name underneath?
Yes, ma'am.
Your Honor, the state tenders as evidence State's Exhibit 1AS.
No. Any objection? States 1AS is admitted for purpose of plea.
Good afternoon, Mr. Sledge.
Good afternoon, Mr. Shaw.
All right. We had just, last thing I asked you was about your representation. Do you recall?
Yes.
Okay, and that you had not hired Mr. Wright for trial.
No.
Okay. On December 28th, 2022, okay, you were aware that, well, let me back up. Typically, have you ever had appointed counsel?
Objection, relevance.
Just trying to educate on how it usually works. I'll move on. Okay. On December 28th, 2022, you were aware of co-defendants on this case who had been arrested.
Yes.
And there were some of those individuals who could not afford attorneys, correct?
Right.
And you were aware that some of those individuals were in Rice Street.
Yes.
Or they were in Rice Street.
Yes.
And those individuals that could not afford attorneys had not been appointed attorneys as of December 28th, 2022, correct?
Yes.
Okay. And isn't it true that you did not want to be in their position?
Yes.
Meaning you did not want to be in Rice Street without an attorney?
Yes.
Okay. You believed, for the purposes of having representation, it was in your best interest to resolve your case via plea on December 28, 2022.
Yes.
Okay. Do you know what coercion means?
No.
Okay. What about pressure?
Yes, I know what pressure means.
Okay. Being in, and this is your truth, I'm not asking for a legal definition, okay?
Yes.
Okay. Being in Rice Street for 7 months prior to your plea, did that put pressure on you to plead to accept this deal?
Yes, a lot.
Okay. Being separated from your sick mother and your children.
This line of questioning is already been, so asking me.
Your Honor, he testified for 3 days already. I've been going for 10 minutes.
Yeah, but you did already ask him that.
Well, I'm just trying to conclude this line of questioning, then I'll move on.
Okay.
I haven't asked him about pressure yet.
No.
He wanted to go home, and now I'm asking about pressure. Being separated from your sick mother and your children, did that create pressure to plead guilty on December 28, 2015?
Yes.
Excuse me, December 28, 2022.
Yes.
And the fact that you did not have a lawyer for trial, did that create pressure on you?
Yes. Fact.
As an answer, relative goes beyond.
How about facts not in evidence too?
The fact that you had not hired an attorney for trial, did that create pressure on you to plead guilty?
Object, that assumes facts not in evidence. And it also calls for speculation.
Overruled.
The fact that you had not hired an attorney for trial, did that create pressure on you to plead guilty on December 28, 2022?
Yes.
All right, I want to talk to you about the plea offer. And when you need to, you can refer to it, but I want you to listen to my questions, and if you can answer without, that's fine.
Yes.
Okay. At some point in late December 2022, you became aware that the state was making a plea offer in your case.
Yes.
Okay. And the state's plea offer was an offer for probation.
Yes.
Okay. And probation, I know we know what it is, but for the jury, probation is you don't have to be in custody, right? You're released.
Yes.
Okay. And you have to check in with a probation officer.
Yes.
In your mind, that's preferable to prison.
Yes.
That's preferable to sitting in Rice Street jail, correct?
Yes.
Okay. Probation would get you back to your family.
Yes.
Get you back to your ill mother.
Yes.
And that would solve your issues as far as hiring an attorney to try the case.
Yes.
You were interested in a plea for probation.
Yes.
Okay. Now, as it turned out, there were factual acknowledgments that you would have to initial to receive that offer of probation, correct?
Yes.
Okay, when you first learned about probation, did you realize that there would be factual acknowledgments that you had to initial?
No.
Okay, but at some point your attorney told you to get this probation, you're going to have to agree to factual acknowledgments.
Yes.
Okay. Let's talk about the factual acknowledgments. Do you remember the first time you saw the factual acknowledgments on that plea form? Was it December 28th?
Yes, I want to say yes.
Okay. Could it have been earlier? To the best of your recollection.
Yes, I think if I'm not mistaken, yes.
Okay. Did you ever write a statement with your truth about what happened in 2015 and give it to Miss Love or any other prosecutor in this case?
Objection vague as to your truth and what had happened in 2015, vague overall.
Did you say 2015?
I did. About what this case is about. Did you ever write a statement?
Objection
Oh, about, not in 2015.
No, about 2015.
Overruled.
No.
Okay. Did you ever sit down with Miss Love before this plea?
No.
Okay. Did you write the factual acknowledgments?
No.
Okay. On that sheet of paper in front of you, I believe it has, do you know what letterhead is?
I think it's the stamp, something like that.
Okay, on the top of the paper.
Yes.
Is there letterhead that indicates Whose office that paper is from?
It's a Fannie Wilson. That what you talking about, right?
Yes.
Yes.
Okay, from the Fulton County District Attorney's Office?
Yes.
Okay. Do you know who wrote the factual acknowledgments?
No.
Okay. Who presented the factual acknowledgments to you? Was it Miss Love?
Yes.
Okay. Did you know Miss Love back in 2015?
No.
Was she hanging out with you in 2015?
No.
Okay.
State filed a notice of a probation revocation for the defendant as to his violation of the special or a special condition within the sentence that he received from Judge Glanville on December 8th of 2023 as it relates to his reviewing, acknowledging that the factual acknowledgments that were a part of the plea agreement in which he entered into on December 8th of 2023. I have a certified copy of the conviction for Your Honor with a certified copy of the indictment, as well as a copy of the transcript of the plea that was taken on December 8th of 2023. An exhibit within that plea transcript is the plea agreement, which includes the sections, I believe it's sections 4 and sections 5 of the plea agreement as it relates to the factual acknowledgments that the defendant swore under oath during the plea that he had reviewed, then initialed each one of the factual acknowledgments, and then signed that he, again, understood and had reviewed each one of the acknowledgments that he initialed as part of the special conditions of his plea, that when called to testify, if called to testify, that the specific factual acknowledgments within the plea agreement were true and accurate statements, and that would be the testimony that he would provide as it relates to his witness testimony during the trial of this case. So I would present to the court State's Exhibits 1 and 2, as well as a USB drive of the defendant's testimony on day 124, 125, 126, and I think 127, Your Honor, but all of the defendant's testimony can be found on State's Exhibit 3. As everyone is aware, Your Honor witnessed it and can take judicial notice of everything that occurred during the testimony in which Mr. Sledge did testify. And I believe the court during, I think it was day 125, helped direct the defendant to sections 4 and 5 of the plea agreement during the testimony for him to focus on and read and to go one by one and acknowledge or disavow is the only word I could really think as to being no longer true and testifying under oath that he was violating the special conditions of his probation, Your Honor. So this time I would tender State's Exhibits 1, 2, and 3 for the court.
All right, I'm not quite sure I understand what 3 is.
3 is a USB drive with all of the testimony of the defendant, if Your Honor wants to preview it or wants to be part of the record.
Is that from the official transcript?
Well, it's the YouTube link, the live stream of all of the...
Okay, I'll just take judicial notice of it. I mean, if you want to make an exhibit, that's fine, but I'm not going to be relying on that. Since, as you know, it's only the official transcript that is the official transcript anyway, but I was here and witnessed it, so I will take judicial notice of it.
Yes, and I'm very much aware of that. The transcript obviously is not ready as we're still in the midst of the trial.
Right.
I didn't want to overwhelm the court reporter who has been doing nothing but probably working hardest out of everyone in the courtroom. So I knew Your Honor either could take judicial notice or rewatch it. Can I approach it?
You may. And can you try to use a mic, please?
Yes, Your Honor.
Can I? They go to the court reporter.
Nothing further from the state at this time, Your Honor.
All right. Mr. Wright?
Your Honor, may I remain seated or?
It's probably easy. You can. It's probably easier to hear you that way.
Okay, I think I'm on. Your Honor, if it'll please the court, I believe, and I already sent to the court defendants 1 through 6. Defendants 1 through 5, I believe, were already, I think my emails between myself and Ms. Love came into evidence during our testimony.
Came into evidence in the trial of the defendants that are on trial right now.
Yes, Your Honor.
Yes.
So those are sort of resubmissions
Okay.
of those, but I do think they're already before the court, or the court can potentially take judicial notice of that.
What is your Exhibit 6? I think I
Well,
only got 5.
Exhibit 6 is the one thing, and that's just a listing of my emails in December between myself
Oh, that's
and
this
Ms.
one
Love.
page?
Yes.
Okay, it didn't have an exhibit marker on it.
I'm sorry,
so
Judge.
that's fine.
So succinctly, I thought it best to submit these exhibits. When you look at Exhibits 1, 2.
And those are admitted for purposes of this record, which is the probation revocation matter.
Thank you, Judge. When you look at Exhibits 1 and 2, what you see going on is plea negotiations in this case started on December 27th between myself and Ms. Love. You can see it's in the evening hours, and that's one reason I wanted to make sure that the sort of cover page along with the attachment are part of these exhibits. At approximately 4:57 p.m. is when the email first comes in from Ms. Love. You see that a second one, Defendants 2, comes in at 5:06 p.m. And at some point I respond. Those are the only 2 exhibits, or the 2 drafts, which occur on the 27th. However, it's important to note that when you see the response that I send to the email at 5:06, I send that response at 8:42. And I point out specific issues with the draft that need to be revised.
Right.
Now,
Yeah, and I recall we discussed this during the trial of this, the ongoing trial as well.
Yes, Your Honor. And the point I won't belabor it is these revisions you actually see being put into the drafts. So by the time you see Defendants 3 and Defendants 4, they note that there's attachments updated to. You see that those very revisions that we requested are being put into the actual drafts. And ultimately, it was Defendants Exhibit 4 that if you look on Defendant 6, when the email comes in, it says, use this one. That is the agreement that we thought we were executing on the 28th. And remind you, on the 28th, we're in court. This isn't where I'm at my office. I can print it out, look at it, take it to the client like we did on the 27th. On the 28th.
On the 28th, both you and Mr. Sledge are in person in this courthouse, right?
Correct. So the emails, if you notice, I never respond because I'm here. I'm in person.
Right.
So we would get it and via phone, or if they would give me a draft, to take to him, I would literally go from the conference room back to the holding area. We would go through it, go over it. But the one that we thought was going to be the executed final was the same one that they said on Defendants 4, use this one.
But are you testifying now, or are you just recalling for me the testimony from previously during this ongoing trial?
I am asking the court to take judicial notice.
I will
testified
take
to
judicial notice of what both you and Mr. Sledge testified to in the trial. I recall it.
Understood. So, ultimately, the last thing that I think we mentioned in our testimony was where we did take issue with some things. We said, he'll have a chance to answer the question and to explain. Now, there was a big problem, and I noted in my testimony that number 8 on that version that got signed had been taken out, removed. All of a sudden it reappears and it's there. My client initialed it. Yes, it was tendered. But ultimately, here's the problem. My client has always said he does not know who's responsible for shooting the victim, who he never was a participant or heard about planning the murder of the victim, and therefore number 8 was put into evidence by Ms. Love to the court when it was a knowing statement. She knew that that statement was false. That is,
Yeah, I'm not sure about that. That may be your contention, but.
Well, we would contend to the court that where my actual email defendants 2 clearly denoted that.
It does not. That is up for debate what that denotes.
It is removed from all the drafts and then ends up back in.
That is true.
So.
But your response on your Defendant's Exhibit 2 to item, what is then item number 4, does not definitively state anything like what you just said. He said he did not know, as we discussed at the time of the ongoing trial, could have been interpreted in several different ways. But I understand what you're saying.
And just so
You maintain that the two of you both missed the fact that you signed, or your client signed, a factual acknowledgement that included item number 8.
Correct.
And then when Ms. Love read it out orally in the court, and Mr. Sledge, one by one, said, yes, I acknowledge that somehow that didn't occur to you at that point in time either. So I understand what the assertion is. Here's the thing. You seem to be focused almost wholly, if not wholly, on, well, maybe there was a mistake with regard to factual assertion number 8. The issue that I see is that the state has not limited their petition to revoke probation to, he contradicted or he refused to acknowledge during the trial that item number 8. It is the entirety of disavowing factual acknowledgments, et cetera. And what got disavowed under oath in this trial was far more than just item number 8. It was item number 3, item number 4, item number 5, item number 6, item number 7, item number 8, item number 9, item number 16, and then the part 5, sentencing acknowledgments, number 1, number 2, number 3, number 4, number 5, number 6, and the paragraph underneath asserting that he's read and that they're true and that he understands that he's had an opportunity to discuss it and he voluntarily enters into it, et cetera, et cetera. So even if we entirely disregard item number 8 of the factual acknowledgments, there are still however many other ones that added up to that the state is still relying upon. And I don't see how you get around, and maybe you have a way to get around the rest of it, and I'm certainly willing to listen, but that one thing is sworn to in open court on December 28th of 2022, and then something diametrically opposite of that is sworn to under oath back on September 5th of this year.
I understand your concerns, Judge. One of the things that we traveled on after taking the plea was he would be able to explain his answers if he had issues.
Can I ask you a question about that? Is there anywhere in the guilty plea agreement in sentencing of your client in December of 2022 where you reserve that, where anybody, the state, the defense, or the court puts on the record that that's part of the understanding?
It is not in the written plea agreement, no.
All right.
However, in evaluating my client for the purpose of this hearing, I don't think the state is denying that that is something that it was understood, understanding it's not in the written plea agreement, but it was understood. And the other thing to also take note of, my client, when asked to make himself available, to meet with the state, to be prepared by the state, at all times would show up and do that. He was never provided or questioned it with any details such as, here, let's go over your plea agreement, these factual allegations, what questions may be asked. In other words, what you saw at trial was someone who was now, after, what was that, December of 22, was now, for the first time, being drilled, or asked questions, rather, as to the specifics of all the things that he had allocated, all the questions that were going to be asked. There was no preparation of him. So what you saw was probably frustration on his part at times, and shutting down at times on his part. But it was also part of the manifestation of what happens when a witness who's not a lawyer, who's not someone used to this, is getting questions fired at them. And at some point, I think the court can take note that he literally shut down. And some of what the court saw may be more of a manifestation of being overwhelmed as opposed to trying to purposely change or diametrically say something different than what ultimately he allocated initially. So I, in retrospect, wish the state had actually, more than general questions, actually prepped him like you would normally see a witness be prepared and prepped. That did not happen. So you saw a very raw witness recounting things that happened quite some time ago, and did not necessarily say things consistent with what he said before. But it wasn't simply for a malicious intent or an intent to deceive. There were several factors, is all I'm indicating, that may well explain why it was so difficult during his testimony.
All right, anything else you want to present?
Your Honor, not at this time, no.
All right. Can the state give me a quick rundown of what this defendant's prior history is, including any prior probation violations? And then I guess I know that the probation officer is on here, so I'd probably need to at some point ask that officer if they would like to be heard as well.
And Your Honor, we would defer to probation as it relates to, I know they have a full account of his history as
All
it
right,
relates to.
you know what, I think I'm still on Zoom. Yes, Judge. Yeah. And what's the officer's name?
That's Jolly.
Oh, it's my regular probation officer from long ago, whom I haven't seen in the last 2.5 months because I've been otherwise occupied.
Hello, Judge Whitaker.
Hello, I'm trying to, oops. Okay, I'm trying to get myself on video. Ah, I know. So that it's not a disembodied voice. Hang on. All right. Hello, Officer Jolly.
Hello, Judge.
All right, what is probation's, can you give me a rundown of Mr. Sledge's criminal history? And I'm sure you heard the question I just asked, as well as any prior probation violations?
Well, currently, he'd used his first offender twice, one for DeKalb County, one for Fulton County.
Well, that's lucky
The
of
DeKalb,
him. Since you're only supposed to get to use it once. Okay.
yes, so the DeKalb County case, 04CR 24799, that was theft by receiving stolen property, felon, and a obstruction of law enforcement officer, which was a misdemeanor. That was May 19th, 2005. I'm sorry.
Okay.
He used his first offender. The second case, 04SC 23883, that's Fulton County. He used his first offender. That was possession of cocaine, as well as a possession with the intent to distribute cocaine. That was December 10th, 2004. The possession with intent to distribute cocaine in Fulton County was January 3rd, 2014. Again, both times, all three times, he used his first offender. The next case is 15 SC 138994. That is a Fulton County case. That is the gang participation, aggravated sex battery, attempted aggravated sex battery, aggravated battery, aggravated assault, criminal damage first degree, criminal damage second degree, and possession with a firearm by a convicted felon. That was January 10th, 2018.
All right, so given the fact that he had at that point a possession of a firearm by a convicted felon, does that indicate that at least one of those first offenders was not successfully completed?
One
Or are we
moment.
missing a felony?
One moment.
He was adjudicated guilty.
That would be correct, Your Honor. In addition, of course, the current case that he is currently on probation on. As far as previous revocations,
So, hang on, so the 15 SC and then this 22 SC case, right? Is there anything
Correct.
between the two of them?
there's nothing in between the two of them, no.
Okay. Are you looking about prior revocations or prior violations?
Yes, at this present time, I don't see any prior revocations. There was one documentation. It's a little bit, I guess, I'm having a hard time understanding what they meant by it. One moment.
Judge, while she's pulling that up, there is a 13 SC 123423 out of Fulton County. It's a VGCSA, possession of cocaine with the intent to distribute, where the defendant received 5 years probation on January 7th, 2014, which would be the predicate or basis for the possession of a firearm by a convicted felon of the 15 SC.
I figured there had to be something else there. Okay,
Sorry, I should have spoken sooner. I apologize.
appreciate it.
Yeah, the only documentation that I have regarding a revocation just said revoke closed July 16, 2008. Doesn't really show any actual time served or any time being revoked or continued on probation back in 2008.
Okay.
So I'm unsure if that's an actual revocation that was completed.
Okay, well, yeah, it sounds like maybe it was revoked, but it was just wrapped up in something else is how I would take that. I don't know, but, or that that a violation was found, but we don't know what that was or anything like that. All right, so does probation have a recommendation in this case?
Due to the last minute notification of this probation revocation, I would leave that up to the courts to make that decision.
Okay. All right, well, I find there to have been a violation as alleged, and again, even discounting the item number 8. What is the state's recommendation?
In full candor to the court, Your Honor, I'm going to leave it, the state is going to leave it in the full discretion of the court. Your Honor is fully aware of the conditions. Your Honor witnessed the testimony and how it affected the trial of the case, and I'm going to let Your Honor be the full steward of deciding what the penalty should be as it relates to all of the time that Mr. Sledge still has remaining on probation.
All right, well, I know that at least, I believe in the petition for revocation, the request is that the entire 30 years be revoked, is that right?
It's not the request.
Or is, oh, you're just telling me that's what he has at this point, although it can't be all of it, right? I mean, he's been on probation for at least a couple of years, and did he serve it? What's left?
He just started on December 8th of 2023. I think he got credit for the time. I think he was in for 2 years, so he would have 26 and change, or 25 and change.
I'm sorry, correct, 22.
My bad.
The exact number.
Okay.
That would be 27 years, 7 months, and 8 days.
All right. All right, thank you. Anything else from either side?
No, Your Honor, nothing further from the state.
Your Honor, if it'll please the court, I understand the court's ruling that there is a violation. Ultimately, I guess to some degree, while it's not clearly akin to a substantive versus technical violation of probation, it is a non-violent, non-new offense kind of violation, and I would say if the court is going to violate my client, it would be more germane to treat it as a technical violation. We have expressed to the court different thoughts and reasons for the way the testimony came out. We don't know what effect, if any, one way good or one way bad, that has had. But in terms of his violation, I would ask the court treat it more as a technical. He has one grandchild on the way, one that just came early this year with Ms. Jaquila Freeman. So the point is, he has been staying out of the way. He's been complying with probation. I would ask the court to maybe consider if you want to put more restrictions and make his probation much more of a, not just something he's on, but something that now has more teeth to it because he's been working. He's been taking care of his family. He's staying out of trouble. He's turned that corner. And literally, it was always our hope he wouldn't have to come in and testify. And there was a reason the state allowed this plea to go forward so that he could step away. And in doing so, if you recall, you may have remember from his testimony, by no fault of his, he was a victim of a crime where he was shot multiple times and had to recover from that. So we would ask the court to consider some restrictions first as opposed to custody. And if you do go with custody, we would ask to consider it as a technical type of violation, not a substantive violation in which you would be authorized to give him an even greater sentence. So we would leave it in the discretion of the court, but we're asking again for a non-custodial revocation punishment.
Okay, well, I don't view it as a technical violation or akin to a technical violation, considering the solemn oath that he took when he said that he understood every term within the plea agreement, factual acknowledgments, and sentencing acknowledgments, and understood and, in fact, orally answered that he understood when both asked by the prosecutor and the court at his plea hearing that a failure to abide by any of the terms would constitute a violation of the agreement, and he was notified that the entirety of his probation could be revoked. I do appreciate the fact that this particular violation is a non-violent violation. But I also appreciate the fact that some of the many reasons why this could have occurred include the fact that there is just not a proper regard for the judicial system and the seriousness with which an oath in court needs to be taken. I actually view this much more akin to perjury, frankly, than a technical violation. And the sentence for perjury is up to 10 years. I am going to revoke 5 years of Mr. Sledge's probation. And Mr. Sledge, I am sympathetic to the fact that you have generally stayed out of trouble, and I want to commend you for that. And I really hope that this revocation doesn't set you back. But we've got to take seriously the court system. So that's the sentence of the court. I find there to have been that violation. I'm revoking 5 years.
And he will be continued on probation, Your Honor?
And reinstate the balance.
Thank you.
Might I ask, is it possible for my client to turn himself in to make arrangements?
I think y'all knew when you came in here that this was a strong possibility. So, no, I'm sorry. All right, court is adjourned.
Good seeing you, Judge Whitaker.
Yes, thank you. Good to see you.
All right, bye.
The only person we could hear was Miss Jolly, so the only person we could hear was Miss Jolly.
Oh, wow.
Not on Zoom.
I don't know, the sound.
Jolly.
Yes.
All right, states know your first and last name for the course, allow me to the mic, please, sir.
Quamarvius Nichols, Quamarvious, last name Nichols, Nichols.
Did you
All
get
right.
that, Judge? Okay. Do you want to do it again? All right, slow down. Your name, spell it for this young lady right here.
Okay, my name is Quamarvius Nichols, first name Quamarvious, my last name Nichols, Nichols.
And Mr. Nichols, are you the same person referred to as Quamarvius Nichols on indictment 22 SC 183572?
Yes,
And are you at this time taking or under the influence of any alcohol, drugs, or medicine?
no,
Have you had the opportunity to sign this indictment with your attorney, Mr. Bruce Harvey?
yes,
How old are you?
29.
And how far did you go in school?
I got my GED.
I did not hear you.
I got my GED.
Are you able to read, write, and understand the English language?
Yes,
Do you understand that in this indictment, you were initially charged with count 1, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, which carries a sentence of 5 to 20 years. You were also charged with count 49 in this indictment, which is murder, which carries a sentence of life. You were charged with 2 counts of participation in criminal street gang activity, which was counts 50 and 51, which each carried a sentence of 5 to 20 years. You were initially charged with counts 53 and 65, possession of a firearm by a convicted felon under Code Section 16-11-133, which each carry a sentence of 15 years consecutive to count 1. And then you were also charged with count 54, which is possession of a firearm during the commission of a felony, which carried a sentence of 5 years consecutive to count 1. Do you understand that is what you were initially charged with?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had an opportunity to go over and review the waiver of rights form with your attorney?
Yes.
And I'm going to hand this to your attorney. Did you sign this along with your attorney?
Yes.
Have you had enough time to speak with your attorney, Mr. Bruce Harvey, about all the facts and circumstances known to you regarding the charge in this indictment?
Yes.
Do you need any more time to discuss this man with your attorney?
No.
Are you satisfied with his counsel and representation?
Yes.
And I'd include in there the counsel and representation by Ms. Westmoreland and Mr. Garland as well. You had a team of attorneys.
That's correct.
All right.
And they are all attorneys of record and have participated in this particular proceeding and negotiations leading up to this proceeding.
Thank you.
Do you waive formal reading of the indictment?
Yes.
Do you waive any and all defects with respect to the indictment?
Yes.
And to your knowledge, have you been arrested on all the charges in this indictment?
Yes.
And Mr. Harvey, the state is unaware of any outstanding warrants related to these charges. Do you know of any outstanding warrants that are related to these charges?
Not related to those charges.
Have you been advised of the minimum and maximum sentence for each charge that you are pleading to?
Yes.
Do you understand this is a negotiated plea of guilty, which means that the state will recommend to the court as to count 1, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, a sentence of 20 years to serve 7 years in custody, balanced on probation?
Yes.
Do you understand as a part of the negotiated agreement, the state will null, or dismiss count 49, which is the murder count, count 50, 51, which are the gang activity counts, count 53, possession of a firearm by a convicted felon, count 54, possession of a firearm during the commission of a felony, and count 65, possession of a firearm by a convicted felon. Do you understand that is the negotiated agreement?
Yes.
Do you understand that the court does not have to accept that recommendation?
Yes.
And the court can sentence you to the maximum on each charge and can run those charges consecutively or one after the other?
Yes.
Well, there's only one charge that
so
a guilty plea is
I'd
being
listen-
entered into, so
Under my breath to that.
there's no other sentence to run anything consecutively with regard to this plea. You understand that?
Yes.
Okay.
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts?
Yes.
Do you understand if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of your sentence?
Yes.
Do you understand you are not allowed to possess or use a firearm while on probation?
Yes.
Do you understand if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that is true regardless of any advice by your attorney or anyone else?
Yes.
Do you understand that neither the court, your attorney, nor the district attorney's office has anything to do with parole, the Department of Corrections, or Board of Pardons and Paroles, and no one can guarantee parole no matter what anyone has told you?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, your right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you'll be guilty of a felony, which may carry a sentence of 1 to 15 years in prison.
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand if you went to trial, you have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify to remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights? After each right, I'll ask you to say yes or no if you understand. The right to a trial by jury,
Yes.
the right to remain silent and not incriminate yourself,
Yes.
the right to confront witnesses against you,
Yes.
the right to assist of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at the trial of your case,
Yes.
the right to the presumption of innocence,
Yes.
the right to testify on your own behalf and to present other evidence,
Yes.
the right to subpoena witnesses and compel the production of evidence,
Yes.
the right to have the charges against you proved beyond a reasonable doubt,
Yes.
the right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes.
With respect to indictment 22 SC 183572, how do you plead to count 1, conspiracy to violate the Racketeer, Influence, and Corrupt Organizations Act?
Guilty.
Is this guilty plea freely and voluntarily given with a full knowledge of the charges against you?
Yes.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have 4 years from today's date to file a habeas corpus petition challenging the voluntariness of this plea?
Yes.
And that can challenge anything about the constitutionality of the plea. It's not limited to voluntariness, understand?
Yes.
And Your Honor, if this case were to
Hang on just a second. You also have, so 4 years for that to file a direct appeal. You have 30 days from the date of the sentencing, which is going to be today. And you have until the end of this term of court to file a motion seeking to withdraw your guilty plea. That doesn't mean anything like that would be granted. You would have to establish facts that would warrant that. But that's just the time period is until the end of this term of court. Do you understand those as well?
Yes.
All right. Your Honor, if this case were to continue with trial, Your Honor, the state would expect, as to this defendant, the state would expect to show that what has already come into evidence that on July 3rd, 2017, as well as October 23rd, 2018, that this defendant is an associate of the enterprise of YSL, also known as Young Slime Life, and that he conspired to associate together with others for the common purpose of illegally obtaining money and property through a pattern of racketeering activity and conducting and participating in the enterprise through a pattern of racketeering activity. In furtherance of the conspiracy, this defendant engaged in the activities below. He engaged in activities that assisted with preserving, protecting, and enhancing the reputation, power, and territory of the enterprise through acts of racketeering activity to include murder, assault, and threats of violence. That this defendant preserved, protect, and enhance the reputation, power, and territory of the enterprise by the posting of messages, images, appearance in videos, and songs demonstrating allegiance to the enterprise and a willingness to engage in violence on its behalf, and to obtain money, weapons, and other property through acts of racketeering activity, including the unlawful sale and distribution of drugs. Your Honor, evidence has come in during this trial that on July 3rd, 2017, Mr. Nichols was located at 2612 Steele Avenue, which is in the Cleveland Avenue sector of the city. Your Honor, he was found inside of a vehicle. When that vehicle was searched, Your Honor, this was in October of 2018, they found marijuana as well as sandwich baggies that would be used to package drugs, and there are also guns found inside of that vehicle. Also in July of 2017, this defendant was stopped during a traffic stop in the Cascade area, Your Honor. After being stopped, Your Honor, there was a consensual search of the vehicle that yielded powder MDMA, Xanax, as well as a loaded gun inside of that vehicle. Additionally, Your Honor, in July of 2019, Mr. Nichols was featured in a video with another YSL member, Shannon Stillwell, and Woody Lee. In that video, it was entitled Slap Talk. And in that video, co-conspirator Shannon Stillwell, while performing, makes such quotes as, "Me and my slimes are above the law." We know from the evidence that slimes is one of the terminology used by members of YSL to refer to themselves or other members of this enterprise. And then last but certainly not least, Your Honor, that in March of 2022, Your Honor, Mr. Nichols was found in surveillance video at a gas station at Windsor Street and Fulton Street here in Atlanta, Georgia. This was on March 14, 2022, during what the state would believe to show an onset of a gang war that really started in 2015 with the death of Donovan Thomas, but carried on into 2022. In February of 2022, a rival gang member by the name of Rayshawn Bennett, also known as YFN Lucci, was stabbed at the Fulton County Jail in February of 2022. Information about that stabbing was made public at the early part of March 2022, around March 3rd of 2022. Once that information was released to the public, there was an onset of retaliatory activity that occurred between March 3rd, 2022 and March 16th of 2022. That includes a March 11th homicide of YSL associates Christian McMiller and Darius Ford. It also then included a retaliatory shooting of a YFN associate, and then ultimately it led to a murder of Shamel Drinks, who we believe is a YFN associate. This murder occurred again on March 14, 2022. Mr. Nichols is seen on surveillance video at that BP gas station, as I just referenced earlier. He was at the gas station with YSL co-conspirator Shannon Stillwell. Mr. Stillwell was driving an Audi vehicle. Mr. Nichols came to that gas station in a Ford Fusion vehicle. You see both of them on camera together. While they are at that gas station, Shamel Drinks approaches that gas station as well. I think unbeknownst to Mr. Drinks, Mr. Stillwell was still in his vehicle, which is the Audi. At some point in time, Mr. Nichols got into his vehicle, the Ford Fusion. Once Mr. Drinks finished his business or finished handling business at that gas station, we know that there is a phone call between occupants of the car that Mr. Stillwell was in and occupants of the car that Mr. Nichols was in. That communication was to the effect of, you need to get on FaceTime. As soon as that conversation ensues, we see Mr. Drinks leave the gas station in his vehicle, and both the car that Mr. Stillwell is driving, as well as the car that Mr. Nichols is driving, both follow out of the gas station, following behind Mr. Drinks. Mr. Drinks proceeds down the street to the light at Windsor, which is right by I-20 in Windsor. Mr. Drinks is in the far left lane. The car involving with Mr. Stillwell pulls up to the middle lane, and Mr. Nichols' vehicle pulls up to the far right lane. This is all captured on surveillance video and surveillance camera. They are at the light for a moment. Then we see both this car with Mr. Stillwell as well as the car with Mr. Nichols drive through a red light, leaving the car with Mr. Drinks sitting at that light. About 30 minutes later, a Good Samaritan sees that car still sitting there, approaches the vehicle, and Mr. Drinks is now deceased inside of that vehicle. We had know through LPR readers that both Mr. Stillwell's vehicle and the car involving Mr. Nichols drive in the direction of 20 westbound and follow in tandem. 2 days later, when after the case is investigated and arrest warrants are taken out, on March 17th, 3 days later, Mr. Nichols is found with Mr. Stillwell at a Chick-fil-A gas station, Chick-fil-A restaurant. There is a chase, I won't call it a high-speed chase, but there is a chase through the city of East Point, and eventually Mr. Nichols as well as Mr. Stillwell are both apprehended after arrest warrants were ultimately taken out for the murder of Mr. Drinks, Your Honor. Given where we are in the case, Your Honor, we know that Mr. Nichols, we do not believe Mr. Nichols was in the vehicle in which the shooting occurred, but he was in this other vehicle. The state has made the decision to move forward with this recommendation for the RICO count, Your Honor, for count one.
Mr. Harvey, are y'all acknowledging a factual basis to the count one, the RICO count?
Okay, we are acknowledging a factual basis. There has already been evidence with regard to the July 3rd, 2017 drug event, the October 23rd, 2018 drug event. We categorically deny and contest any use of violence by Mr. Nichols. We don't agree to that underlying factual basis. We believe those two predicate acts that were committed by Mr. Nichols without any question are sufficient to meet the elements of the offense. The offense to which he's pleaded to, which is a RICO conspiracy. A RICO conspiracy requires proof that the defendant either conspire with another person to violate one of the substantive provisions of RICO, and that would be drug offenses, or personally endeavor, I believe that's what the language of the statute says, to violate one of the substantive provisions.
Well, that's what the language of the statute says, but
Yes.
he is indicted in this indictment with conspiring, not with endeavoring.
That's correct. So we're talking about a conspiracy. We acknowledge the two events that he participated in. We categorically deny any other allegations other than those two events that are sufficient for a factual basis. We categorically deny that we participated in any way in the unfortunate death of Mr. Drinks. We categorically deny any other charges to which we are, substantive charges to which we are not entering a plea, and that includes gang charges. This is a plea solely to a conspiracy to violate the RICO Act. So that, but yes, we acknowledge a factual basis to that extent, Your Honor.
Understood. All right, thank you.
Your Honor, we just have one additional thing to say.
Go ahead.
The factual basis regarding the nature of YSL is that the evidence has shown and will continue to show that Mr. Nichols conspired with others to participate in Young Slime Life through a pattern of racketeering activity, and multiple defendants and unindicted co-conspirators have committed overt acts to further this conspiracy, including drug sales, aggravated assault, and murder, also including social media posts asserting the violent nature of and asserted dominance of Young Slime Life, also known as YSL. And that concludes our factual basis.
And again, once again, we again categorically deny those representations. And again, the only thing that is necessary to meet the factual evidence of a 1614-4C is proof that the defendant conspire with another person to violate one of the substantive provisions of RICO, and that is subsumed by the drug offenses that have already been proven in this case and to which Mr. Nichols has previously pled.
All right, thank you. Understood.
And Your Honor, may I approach with the waiver of rights form?
Yes. All right, Mr. Harvey, have you reviewed with Mr. Nichols this plea of guilty and waiver of rights form, which the two of you have both signed?
I have, Judge, in each individual provision in that plea colloquy, has been acknowledged and gone over personally with Mr. Nichols.
All right. And Mr. Nichols, have you had sufficient time to consider this guilty plea that has been negotiated between the state and your attorneys, and to discuss anything you wanted to about that with your attorneys?
Yes.
All right. And you understand, I hope, I'm going to ask you, that it is your decision ultimately, obviously with the advice of your attorneys, but it's ultimately up to you individually to decide whether you want to enter this guilty plea or not. Do you understand that?
Yes.
All right. And you do want to enter this guilty plea?
Yes.
All right. And Mr. Harvey, have you advised Mr. Nichols of the alternatives if he does not ultimately go through with this guilty plea, and the potential benefits and drawbacks of all of the other options?
Yes,
All right.
very thoroughly, Judge.
All right. All right, Mr. Harvey, is there anything that the defense wants to add to the record?
Judge, other than the statement with regard to the underlying factual basis, I would point out for the court that when Mr. Nichols filled out his form, it says 29 plus. He is a birthday boy in a couple of days, and he will be 30. And at 30 years of age, he has a wife. He has got a 13-year-old daughter. He's got a 10-year-old daughter and an 8-year-old son. His wife and sister, I believe, are here in the courtroom to support him. He, Mr. Nichols, was born and raised in Atlanta. And, you know, we're at this point before I have even given my opening statement in this case.
Yes, sir.
I do want the court to know that Mr. Nichols' mother died in prison. His father was shot by the Atlanta police when he was 4 years old. And he was raised by friends and family in the Atlanta area. So he has come to this point in his life from a very humble beginning, and he has sought the support of friends in this courtroom and others in this courtroom. He is an intelligent young man who I believe has a future. Every day we do a word of the day. We put a new word into a sentence. And I think this is in his best interest. I know that there is, and I know this plea is negotiated, but it's a long downside from 7 to 20. So the courts will have jurisdiction over him for a period of time. So I ask the court, given who this young man is, and given our categorical denial of some of the factual basis, to accept the plea and sentence Mr. Nichols accordingly.
Mr. Nichols, is there anything that you want to say?
No, ma'am.
All right. All right, I find there to be a factual basis for the guilty plea to the RICO count one of the indictment, that being a conspiracy to acquire control or interest in money and personal property through a pattern of racketeering activity. And that is the only count that guilty plea is being entered for. The remaining counts of this indictment as against Mr. Nichols are being null pros by the state as a part of this indictment. I find, having heard the evidence up to the point of trial right now, that there is evidence of at least one overt act in furtherance of the conspiracy. And that there is evidence that would fall within the required statute of limitations to establish this RICO conspiracy count. One of the things that we as judges are instructed by our Uniform Superior Court rules to do when we are considering whether to accept a guilty plea and whether to accept a negotiated sentence, and this is a negotiated sentence in this case, is to take into account whether giving leniency in sentencing is going to aid in ensuring promptness and certainty, or at least more promptness and more certainty with regard to corrective measures, whether the defendant, and in this case, the defendant has acknowledged guilt and is accepting responsibility for his guilt of the RICO count, and whether accepting the plea will aid in avoiding further delays, not just with regard to this case, but with regard to the entirety of our system here in Fulton County. And this plea does go towards doing all of those things. I am going to accept the plea as negotiated and sentence in accord with the negotiated recommendation. As I said before, find there to be a factual basis for count one of the plea. I find the plea to have been freely, knowingly, intelligently, and voluntarily entered into by Mr. Nichols with an understanding of the consequences of doing that. And the sentence on count one is the sentence that has been negotiated of 20 years to serve 7, with the balance of those years to be served on probation. And that, I don't know if there are any special conditions attached to this that y'all have talked about at all.
There are no negotiated special conditions in those, so there are none as far as I'm concerned.
All right. Okay. So with regard to the time that you are on probation, you need to stay out of all kinds of criminal trouble. Make this a birthday present to yourself and to your children and to your wife and family, that you will leave from here today and leave whatever you used to do behind you, and take the next few years. You know, you're going to have some years that are still to be served on this. You'll have credit for the time you've already served, but you're still going to be facing some incarceration time. But after that, you are going to be out, and you, I believe Mr. Harvey is correct, can be a productive member of society, and this is an opportunity for you to do that and for you to put your past behind you, the bad parts of it, and continue and make your children proud of you and set a good example for them, an example that I guess unfortunately you were not lucky enough to have throughout the entirety of your childhood with your parents. I'm sorry about that, but you can be the kind of parent that you ought to be to your children. So I am going to impose that sentence, and I am going to wish you luck and good fortune as you go forth from here. So I think that unless there's anything else from either party, that will conclude these proceedings, and y'all can go ahead and take him into custody. Thank you.
Thank you, Judge.
And Ms. Taylor will make this an exhibit to the plea. Thank you. All right, we are adjourned for the day.